Good morning and welcome to the continuation of phase one of the Yonge Bernard KDA secondary plan and the related appeals hearing. Just looking over the list of those pictures I can see, is there any alternate counsel or changed in any way out there?
Yes, Mr. Chair, I can. It's Sarah Kearney here. I'm again counsel for 1087 Yonge Street Limited. The student who was monitoring the proceeding with me, Yasmin, she has gone back to law school, and so I'm now joined by my colleague Jeff Adams, who is an articling student with Fasken. Similar to before, with your permission, I will step away from the proceeding at times, but Mr. Adams will be here monitoring the proceeding on our behalf.
Fair enough. Anyone else?
Good morning, sir. It's Patrick Harrington for Yonge MCD. Ms. Foran wanted to convey that she is involved in another matter before a committee of adjustment in Brampton, so would not be able to attend this morning.
Okay, fair enough, Mr. Harrington. Thanks. Well, Mr. Kussner, preliminaries?
Yes, thank you, Mr. Chair, and good morning. Everyone hear me okay? Mr. Chair, just a few preliminary matters before we resume the evidentiary hearing. You'll recall that before we broke in July, we indicated that we would be preparing an updated hearing plan to guide the remainder of this phase one hearing. We did prepare that. Mr. Kahar took ownership of that. It was circulated to all of the parties, and I can confirm that it is being filed with the consent of all parties with two exceptions. One is Mr. Skander, who continues to have fundamental issues regarding the hearing more generally. I don't think his objections relate specifically to anything on the hearing plan, but it's part of his general objection to the conduct of the hearing. The only other caveat is Mr. Streisfield, who had indicated that in his view, the hearing plan did not allot sufficient time for his cross-examination of Ms. Anderson, which will be taking place this morning, first thing. However, Mr. Streisfield did indicate that he expected that he would be less time with the examinations of his own witnesses. And on that basis, we've sort of agreed amongst ourselves, subject to your concurrence, that we would not be strictly adhering to the time limits indicated here for his cross-examination of Ms. Anderson, on the understanding that we would make up for that time by way of less time for his examinations in chief of his own witnesses. So we're not proposing to adhere strictly to the time limits set out today, but the expectation is that we'll make up for that as we go along with Mr. Streisfield's own examinations in chief.
Is there someone going to be the timekeeper, if I can put it that way?
I expect Mr. Kahar will be keeping a time regimen nonetheless.
Okay.
Thank you, sir.
Okay, fair enough. Any other preliminary matters?
Yes, sir. Just a couple of other things.
Sorry.
Firstly, we have indicated here that the hearing commencement time would be 10 a.m. With your concurrence, we're proposing that going forward, we revert back to a 9:30 a.m. start. I think there's a realistic expectation that we'll be able to complete this hearing based on the hearing plan, but it is tight, and if there's any slippage, it could become problematic. So I think it would be prudent if we allotted ourselves a little extra time each day, and a 9:30 start would go a long way toward assisting in that regard.
My colleague and I agreed that we would get back to the regular routine of the 9:30 starting tomorrow for every day remaining in this part of the schedule.
Thank you, sir.
Fair enough.
The next preliminary matter has to do with witness statements. And you'll recall that in the previous portion of the phase 1 hearing, a redacted issues list was filed as Exhibit 13. And that redacted issues list clearly indicated which issues properly remained the subject of this phase 1 hearing and which issues had been deferred to phase 2.
Right.
And on the basis of that revised issues list, Exhibit 13, the parties were directed to file redacted versions of their witness statements that corresponded to what remains in phase 1 and what's deferred to phase 2. You'll recall that we had filed redacted versions of all of the city's witness statements to correspond to that division. And before we broke in July, we'd had a discussion about direction to Mr. Streisfield to have his witnesses similarly file redacted versions of their witness statements along the same lines. We did not receive redacted versions of Mr. Streisfield's witness statements. We therefore took it upon ourselves, Mr. Kahar and I, to prepare what we consider to be proper redacted versions of his witnesses' witness statements, Mr. Manette, Mr. Pereira, and Mr. Chan. Because we had other things to do, we didn't get around to actually doing that because we didn't expect we would have to be doing that ourselves, but we were able to get it to Mr. Streisfield, I believe, on Thursday last week. So now in his hands, we are waiting to hear back from him as to whether he and his witnesses agree with what we consider to be the proper redactions of their witness statements. I don't think we need to address it any further this morning. Our hope and expectation is that we will hear back from him in that regard well before we commence the examinations in chief of his witnesses later this week. We may or may not have disagreements on what are appropriate redactions, but I don't think we need to pursue it any further this morning.
Okay, fair enough.
The other thing, sir, is an issue has arisen with respect to an exhibit that my friend Mr. Streisfield would like to file and enter as evidence, and it is a YouTube video of the City Council public meeting that took place on May 13th of 2020. You'll recall that there was a council meeting, a public meeting on May 13th. It ultimately culminated in a council resolution, and the following day, May 14th, there was a closed session council meeting which resulted in a reconsideration of the May 13th decision and a rescinding of the May 13th council resolution. My friend would nonetheless like to enter as an exhibit the YouTube video of the May 13th public meeting. I'm in the tribunal's hands as to whether you want to deal with that now or later. In general terms, it's the city's submission, and this is consistent with Mr. Makuch's, Vice Chair Makuch's decision of June 29th, that the decision reached on May 13th is of marginal relevance at best. Firstly, it's important to bear in mind whether it's the May 13th decision or the May 14th decision. These appeals were already before the tribunal, so council was not deciding anything in the capacity of an approval authority. On top of that, as I pointed out, the May 13th decision was rescinded by the May 14th decision. That said, we do acknowledge that under Section 2.1 of the Planning Act, the tribunal is directed to have regard to the materials that were before council when it made its decision, and the materials that were before council on May 13th presumably also informed in part its decision on May 14th. So to that extent, we acknowledge that the tribunal can and perhaps should have regard to the materials, but as the city submission, that that's something the tribunal can and should be doing on its own time. It should not be something that should be the subject of evidence. It's something that the parties can make submissions on as part of their closing arguments. And if, for example, somebody wishes to make a submission that the submission of so-and-so at 1 hour and 32 minutes of the YouTube video on May 13th is something you should have regard to, they can certainly refer you to that, and the tribunal can, in our submission, have regard to it at its own leisure and at its own time, rather than taking up valuable hearing time to deal with it. So that's our submission with respect to that video. I don't know if we want to deal with that now or if we can deal with that later.
I'm not sure what he said.
Is there any?
I'm not
Sorry,
sure what he said.
my understanding is that it's not streaming.
It is on the city's YouTube page.
It's on the city's YouTube page. Okay.
I'd like to.
Okay, my colleague is going to start off.
I'd like to comment on that. In my opinion, and I'll check with my colleague later, I suspect, and I reread Mr. McCooch's decision and Mr. Conti's decision last night. I think Mr. McCooch's decision already decided this matter, that the Municipal Act did not really apply to the enactments, and that I would consider, subject to what my colleague will say, that the council was functus because it was rescinded, that their decisions were rescinded, and therefore the only one before us now to consider at all is the May 14th council meeting and not the earlier one. And please let me know if you disagree.
Mr. Streisfield, it's your, I guess it's your request that you wanted included as an exhibit. Is that correct? So Mr. Kushner has made his position clear. Do you want to respond to what he has said?
Yes, sir.
And to my colleagues' comments as well.
Yes, I think Mr. Kushner was clear that this is evidence that relates to the Section 2.1 of the Planning Act argument as to what this tribunal should have regard to. And whether you want to watch the video at your own time or here, it should be entered as an exhibit.
Do you want to respond to my colleagues' comments in that respect?
In
That
connection,
the matter has been dealt with and is not, should not be before the hearing.
respectfully, the matter has not been dealt with. This is a hearing on the merits. Anything that Mr. McCooch decided was not on the merits of the merits hearing. It could never bind this panel, which is hearing the matter on the merits. But in any event, we still need to deal with Section 2.1 of the Planning Act, and you will see through our questioning that we have to have some regard to any decision that was made. It's the any decision.
My colleague has already dealt.
Mr. Chair?
Well,
I'm sorry?
This is Jason Cherniak, lawyer for the YRA. Can I comment on this issue before a decision?
Yeah.
So,
Okay, but this is a request by Mr. Streisfield for this particular point in time. Go ahead, Mr. Cherniak.
well, so I was going to respond to Madam Chair's comments. So if it's not about the evidence specifically, but just to say that I thought that Vice Chair McCooch's decision determined that there was nothing contrary to the Municipal Act, at least as far as it is within the LPAT's jurisdiction. I do not believe there was a finding that the May 13th meeting is irrelevant for this hearing or that it should not be considered. I don't think that decision has been made, and I think it's up to this tribunal to make that decision.
Okay.
The panel's decision is that we consider that anything that council revoked or rescinded or whatever the terminology under the Municipal Act, in my mind, the 13th meeting disappeared and is no longer relevant for the merits of the planning decision that was remade, so to speak, on the 14th. And so I would not admit this material. I think it is irrelevant to the decision before the panel now.
So that is the decision of the panel. It will not be brought in, introduced as an exhibit at this time. Okay, anything further? So we're on to the witness in the center of the council chambers. And you are already under oath during the proceedings. Okay. Okay. You're not, you're muted.
Let's start that again. So this is the Mark Engineering letter, the conclusions of which I put to Mr. Gooder in his examination as part of exhibits 44 and 45, and he can confirm the conclusions for me with respect to the so-called signal. And I had sent this around asking that it be marked as an exhibit. This document is already an exhibit in the 2019 hearing that Mr. Conti conducted for Yonge MCD, and I wanted it marked as an exhibit in this particular hearing.
Just the letter itself.
Yes.
Okay. Any issues? And what number, Mr. Kagan, what number are we up to? Hello?
Sorry, I'm sorry, I had to go off mute. We're
Nope.
up to number 46.
6, okay.
And if Mr. Streisfield could tell me now how he wants it described, I will type as he speaks.
Mark Engineering.
Letter of February 20th.
Letter dated February 20th, 2019, regarding Yonge Street new road signalized intersection.
Thank you.
It is 46.
Oops, I gotta stop sharing that. Get that out of there. Okay. Thank you, Ms. Anderson. First of all, have you had an opportunity to review Exhibit 46?
Not immediately.
Okay. Now, as I understand, when we left off, Ms. Anderson, you filed a redacted witness statement, which got marked as Exhibit 36.
That's correct.
And there was a redacted reply that got marked as Exhibit 37.
Correct.
And if I understand, there was Exhibit 34 and 35 that, you just correct me if I'm wrong, were proffered as amendments to your witness statement as of July 9th, 2020?
Yes, Exhibit 34 and 35 were further modifications. Exhibit 34 being to the Part 1 plan and Exhibit 35 being to the secondary plan. And these were based on revised modifications and agreements between the city and TSMJC. And they were both dated July 9th and presented in my evidence, yes.
Thank you. It's my understanding that through North Elgin's planner, Michael Manette, he has signed off, consented to amendment to the Part 1 plan. In my mind, that has occurred. Is that your understanding?
Yes, Mr. Chairman, it is, but I would note that when you're referring to Mr. Manette's agreement on Exhibit 34,
Yes.
there were, as a result of my discussions with Mr. Manette without prejudice,
Yes.
some further wording that has not been presented or discussed at the hearing. It is not subject to review at this time by DSMJC, but there are some further wording that both Mr. Manette and I, and without prejudice discussions, have put forward.
Okay, I just want to be clear from my understanding is that based on Mr. Manette's advice to me, NEC has no issues with the Part 1 mods.
If that's your understanding, my understanding is there is some further wording that was sought, and the discussions between us was that we agreed to that further wording, but that has not been presented. So if Mr. Manette is comfortable without that, I'm not aware of that. The final sort of discussions were an agreement on that additional change. So if that's perhaps something Mr. Manette could put forward.
So my expectation is that we would walk in this morning and NEC would not have any issue with what was Exhibit 34 in any revised format. So is there?
Sorry,
Mr.
Mr.
Chair,
What's
Chairman,
left
I'm not
is really what I'm trying to
awkward.
understand. I want to get this. I want to be done with Exhibit 34 and any mods to the Part 1 plan. I think, I thought we were done.
I'm certainly comfortable, Mr. Chairman, with Exhibit 34 as it's presented. I'm only indicating to assist the board that there have been further discussions with some minor tweaking to wording. I'm fine with the current wording. That additional wording is not required, but may be a slight improvement in my opinion. So, but it's not before the tribunal.
Mr. Chair, if I can assist.
Can you hear me? Yes. If I can assist, Ms. Anderson has indicated that aside from what's on Exhibit 34, which are the agreed modifications to the Part 1 official plan, there was one further proposed modification that she had discussed with Mr. Manette. That further proposed modification is still under review by other parties, including TSMJC, which has not yet signed off on it. My suggestion is perhaps for the time being, we can proceed on the basis of 34 without any further modifications. If by the time we get to Mr. Minette's evidence, Mr. Minette still wishes to recommend the additional modification that we've been discussing and TSMJC has signed off on it, we can then present a modified version of Exhibit 34 at that time.
Okay. So then that takes us to okay, so we'll leave Exhibit 34 for now. And I was told that we should use the August 31 version of the secondary plan that I think was sent to us. It's supposed to be a consolidated version, at least as of July 10th. I just need to know which one we're using going forward.
So on that one, Mr. Chair, the document that Mr. Streisfeld just referred to is a version, an updated version of the proposed modifications to the secondary plan, which was circulated on August the 31st. From our perspective, we're certainly comfortable that it does nothing more than reflect everything that had previously been presented to the tribunal in terms of proposed modifications in one consolidated package. The difficulty is we don't yet have sign off on that document from all of the other parties. In other words, they haven't all confirmed that they're satisfied that that's all it does and doesn't incorporate any additional changes or modifications. For that reason, I think it would probably be premature to be entering that document this morning until we have confirmation from all the other parties to whom that August 31st document's been circulated that they're so satisfied.
Okay, so to be clear then, the document that I'm to cross-examine on is basically the document that was adopted. That was part of the staff report, plus Exhibit 35, on the assumption Exhibit 34 only deals with the Part 1 mods. Is that what we're starting with?
We're satisfied to proceed on that basis.
Okay, thank you.
Mr. Chair, this is Jason Cherniak. We're in the middle of a hearing talking about a document that I don't believe I have seen. Can I ask that I have a copy of that, please? I don't think I received this email on August 31st.
This sad, neither did I.
Sorry, Mr. Chair. Mr. Kahar has clarified for me. To this point, the August 31st document was only circulated to Mr. Streisfeld. We're waiting for him to sign off on it, at which point we were proposing to circulate it to every other party. We haven't yet heard back from Mr. Streisfeld that he's satisfied with that document.
Okay. Yeah, no, I was hoping that we would have had a consolidated version of the secondary plan together with the Exhibit 35 rolled in, so that that would have been simpler just to move forward starting today.
It rather sounds like you're holding it up.
Yeah.
No, it's not me.
Well, just
okay.
to be clear, Mr. Chair, the document we're talking about was sent to Mr. Streisfeld on August 31st. At this point, we are still waiting to hear back from him that he's satisfied with that document.
Okay, fair enough. So I'll just use the version that is found in Exhibit 33, tab 19. There should be a witness copy of Exhibit 33, tab 19, which you will need.
It's in our box way back there.
30,
Exhibit 33.
33, okay.
In this other box too, because it looks like a big one.
Here.
Okay, this, that's all we need for now. Here's 44. Sorry, this should have been organized before. No, I can't, I don't see, oh, 33.
I'll try, but we need
I
to,
have no idea where it is. Is it 33 you do not have? It might be one. Why don't you take mine and we'll just ship. Of course, you're going to need it, and I'm not so much. Thank you.
Sorry,
Sorry,
Mr. Strauss.
we should have had these exhibits well organized by now. We haven't.
Maybe we could be advised of upcoming necessary documents that we could do it prior to the hearing and then be prepared. Okay, go. We got one copy anyway. And the witness has a copy.
so tab 19 of exhibit 33 contained North Elgin's, that tab 19? Of it contained North Elgin's proposed modifications before the hearing started. And that's only in respect of part, the secondary plan. And then tab 20 contained some of our mods to the bylaw. Okay, that's fine. That just hold exhibit 33 for a second. Now, in exhibit 33, there includes a number of tabs, correct?
Yes.
And included in some of those tabs, for example, at tab 3 of exhibit 33,
Yes.
and that and tab 3 is a submission,
Yes.
and tab 4 is a submission.
Email, yes.
And we're going to come back to tab 6. In tab 13 is a submission.
Yes.
And in tab 16, we have a submission.
Yes.
And in tab 16, and I believe it may well be in the joint document, Brooke, I don't remember, but in tab 16, we have included in that the March 13th, 2020 report from Lee Consulting,
Yes, that's attached. Yes.
right? Okay. And tab 17 is a submission.
Yes, to the open house. Yes. Sort of. Looks like
Okay.
it's like a PowerPoint type presentation.
Thank you. Okay, so I believe I have on screen, share screen, section 2.1 of the Planning Act. Can we see that there?
Yes.
So with respect to the documents that I took you to as submissions,
Yes.
would you agree with me that the tribunal must have regard to those documents before making any decision? Correct.
Mr. Chair, I'm going to object to the extent that this is a question that relates globally to a whole raft of documents that my friend just alluded to. I think in part has already been dealt with in the ruling that was just made by the tribunal about 15 minutes ago. So I'm going to object on that basis.
Again?
I thought we were talking about a video, not a document.
That you're making the same argument, Mr. Streisand, from another direction, because in my mind, in law, the council meeting of the 13th is gone. Council changed its mind and went another direction, and therefore, what is the utility of us looking at previous submissions to the council meeting?
So I would have thought the answer to that question is that under section 2.1 of the Planning Act, you are mandated by law. Period.
This question for when it's a determination we must make, not her. She can make a recommendation. You can make a recommendation. We've already dealt with the recommendations on the 13th meeting. Bang.
So this is a question that relates to what information the tribunal shall consider, directly flowing from section 2.1 of the Planning Act. And my question to this witness is, would you agree that the tribunal, pursuant to section 2.1 of the Planning Act, has to consider those submissions that were made before rendering a decision?
Is she agreeing with you?
I'm asking her that question as an expert witness.
But she's not a lawyer.
I can agree. I can see where the 75 minutes is not going to be sufficient. Let's get back on track. And I think we've already made the decision on 2.1. Move on.
Ms. Anderson, in giving the opinions that you gave in July, did you give or have any regard to section 2.1 of the Planning Act?
Giving my opinion evidence, sorry. In giving my opinion evidence, I
Yes.
had regard to all of the information that I had before me. So to that extent, I would have looked at all of the information that was submitted, that was on the record, and made my opinion based on all of that information in my assessment.
Did you, during your retainer, make any submission, either publicly or privately, to council before it made any decision on May the 13th or May the 14th, 2020?
So you asked publicly, and my response would be no. Privately, directly to council, my response would be no.
So if there was a meeting on May the 14th, 2020, you were not involved in it?
That's correct.
And were you involved in a meeting that took place on May 13th, 2020?
Can you qualify involved?
Participated?
No.
Watched? No.
No.
So you were not involved in any of the council meetings relating to the secondary plan that occurred in May of 2020?
So what, did I participate or was I involved in the meeting? No. Am I aware of the outcome? Yes.
Okay. Do you know what information or material council had before it in the closed meeting on May 14th, 2020?
No.
Do you know who would know?
I would suspect legal counsel.
Okay. Now, can we agree that the evidence given by Mr. Falletta was site-specific?
I recall Mr. Falletta did give his evidence as it related to the site, but I also believe he was asked if he had considered the evidence that I had provided and whether or not he agreed with that. And my recollection, his response was he did.
Right. So my recollection is that with respect to when I cross-examined him, that he confirmed that he was not giving any opinion beyond the area of his own client's lot, euphemistically the Longos Plaza, and wasn't expressing any public opinion, planning opinions to this tribunal beyond either his own lands or the southwest quadrant in which his lands were located.
Mr. Chair, this is Jason Cherniak. I object to this. Ms. Anderson was asked to leave the room when evidence of other witnesses being given after her cross-examination was adjourned. If you may recall that Mr. Streisfield was given an opportunity to wait to cross-examine this witness after the other landowners' witnesses had gone forward, she should not be giving evidence that never should have been heard before this cross-examination continued in the first place. I hope my objection is clear.
I'm going to object on similar grounds, Mr. Chair. The fact is, Ms. Anderson was asked to excuse herself from the hearing room during the cross-examination of the other planning witnesses. So I don't think it's fair to put to her Mr. Streisfield's characterization of evidence that she wasn't allowed to hear firsthand.
So let me put it to you then, Ms. Anderson, that neither Mr. Folletta, Mr. Guter, or Mr. Lincoln Lowe gave evidence, opinion evidence, beyond their own properties or their own quadrants.
I'm going to object again, Mr. Chair. I object to the characterization as a mischaracterization, and I object for the same reason that I just alluded to a moment ago with respect to Mr. Folletta's evidence.
Mr. Tricefield? Sorry, who's this?
Well, because he mentioned Mr. Lowe, it's Mr. Kagan here. Because he mentioned Mr. Lowe, I also wanted to object. Mr. Streisfield is free to make whatever submissions he wants to make on the evidence of Mr. Lowe at the end of the hearing, but it's not appropriate for him to characterize it in a very general way and ask for this witness's recollection. We all took notes. We all have our own understanding of what the evidence of Mr. Lowe was.
Move on.
Thank you. In any event, Ms. Anderson, your evidence tended to address the secondary plan and zoning bylaw as a whole.
That's correct.
Okay. And as I understand it, from your witness statement, Exhibit 36, you performed included various policy analysis charts attached to Exhibit 36. So, for example, if we're at Appendix 3, page 103, we see your Planning Act analysis. And as we continue to flip through, we see your PPS and your growth plan analysis. Is that correct?
Yes.
And a similar, I'm going to say, chart was prepared by the city's planning department, and that was included as part of the staff report that went to council in May 13th.
Yes, I believe it was an appendix, yes.
Right, so just as you had created your own charts, thank you, the city had done the same thing.
Yes.
Okay. And on page 114 of Exhibit 36, 114 of Exhibit 36.
Yes. Can you just refer to which document?
Your witness statement?
Yes. I don't have numbers here. I'm just, is it the Planning Act or the Growth Plan?
114. Oh, PPS 1.4.3. I guess that's, I'm just trying to use the paginated numbers that were in the document so that we got a complete record.
Yes.
Right. So in that document, on the right side of the column, we have your analysis.
Yes.
And there are 3 paragraphs in the right side of that box.
That's correct.
And in the 3rd full paragraph, you introduce this concept of providing as of right zoning.
Yes.
You see that? Okay. And I wanted to understand if this is a principle that you ascribe to and you are promoting, by virtue of your opinion, to this tribunal, that we should have as of right zoning.
So in relation to this assessment, I'm indicating that with the secondary plan that's proposed, staff have also prepared a comprehensive zoning bylaw for the KDA, which sets out the zones, the permitted uses, the standards. It is subject to a holding provision, but it is intended to implement the secondary plan such that someone can come forward and develop the property with, if in accordance with all of the zoning provisions, just lifting the hold. And that is, in my opinion, a appropriate and preferable way to complete a secondary plan exercise such that the policies and the zoning are completed at the same time and consistent with each other, and one can implement development through the lifting of a holding provision and possibly a site plan or draft plan.
Okay, thank you. And just along those lines, if I could ask you to open up Exhibit 33, tab 3, the first page.
Yes, I have that. That's Mr. Manette's.
Yeah, just hold on one second, just so the panel gets, are we there at Exhibit 33, tab 3?
Yeah.
So you were just going to refer to Mr. Manette's letter. Just
Yes.
allow me just to come forward. It's my understanding from Mr. Manette's letter found at Exhibit 33, tab 3, the first page, that he had quoted directly from a 2017 staff report.
Yes.
And at least in his mind, as I understand it, and I want to ask you if you agree that the goal of the secondary plan should provide for as-of-right development.
Yes, in reference to the quote,
Yes.
he's noting the key goal, and he's quoting a section of the staff report that notes that it provides direction for long-term evolution of the area. It goes on to say based on comprehensive planning, and then it speaks to the zoning bylaw implementing the secondary plan.
So I just want to be clear, in this letter, if you look underneath the paragraph, he confirms that he agrees with this statement about as-of-right zoning, which
Yes.
originally came from the planning director.
Yes, and he goes on to note some reasons for that.
And my question is, do you agree with this principle?
Yes, as I just stated, yes.
Thank you. So as we sit here today, my understanding is the city is not proffering a zoning bylaw with respect to lands on the east side of Yonge Street. Am I mistaken?
Mr. Chair, I'm not sure what my friend is suggesting. There is, as the witness testified, a comprehensive zoning bylaw. There has already been discussion about what's properly part of phase 1 and what's part of phase 2. The city has already indicated that as an accommodation to TSMJC and perhaps other east side landowners, if that's also their preference, that it's not proposing to have an order implementing the zoning bylaw as part of the phase 1 hearing. Nonetheless, the city certainly intends to have a comprehensive zoning bylaw for the entire secondary plan by the end of the phase 2 hearing.
Going back to page 114 of Exhibit 36, which is your redacted witness statement. In that third paragraph, you write, providing as of right zoning for the area will help to minimize the cost of housing in this area by facilitating a streamlined planning approvals process.
Yes.
Is that still the case sitting here today?
Yes.
And then in that same paragraph, you say that the plan contemplates the integration of a future Bernard bus terminal
Yes.
with new development. Okay. So where is this streamlined planning process? Where is it supposed to come in that you're referring to there?
As I referenced earlier, the planning instruments before the tribunal include the secondary plan and also include the zoning bylaw for the KDA, which includes the zones, the standards and provisions that when adopted would allow developer to come forward with a site plan and lifting of the holding provision subject to the requirements. So could come forward with a site plan and that additional lifting of the hold. And that zoning bylaw is before LPAT. And as I understand, there are portions of that bylaw that are subject to the phase 2 hearing, and there are portions of that bylaw that are subject to site specific issues.
So we can't have as of right zoning.
Once adopted, depending on any further revisions, that as of right zoning would be in place.
Okay. In that paragraph where you gave your evidence, you referenced will help to minimize the cost of housing. See that?
Yes.
What specifically in the secondary plan or the zoning bylaw, by way of policy or regulation, actually assists to minimize the cost of housing in this KDA? Is there something specifically as a policy or regulation that you can point us to that has the effect of minimizing the cost of housing in this area?
So my reference to minimizing costs for housing here is related to process and the implementing documents. And as I indicated earlier, having the policies and the zoning in place provides certainty for a developer to come forward and also allows a site plan process if, again, in compliance with the policies and zoning, which would avoid additional approvals process and timing that could otherwise delay bringing that housing on board. So in relation to an approvals process, streamlining a secondary plan with a zoning bylaw, in my opinion, does allow for the approvals process to be consolidated and shortened to the extent that it could contribute to certainty around bringing housing on earlier.
Okay. And I'm now on page 115 of Exhibit 36, which seems to be a continuation of your policy 1.4.3 analysis. Is that correct?
Yes.
Okay. And if we're looking in the top, there's 4 boxes on page 115. If we're looking in the top left box under subparagraph 4, that is the PPS requirement to establish development standards for residential intensification, redevelopment, and new residential development, which minimize the cost of housing and facilitate compact form.
Correct.
So I'm going to ask you what specific policy in this secondary plan that you're proffering to this tribunal and or regulation in the zoning bylaw that you're proffering to this tribunal that is a development standard which would minimize the cost of housing. Where do I see that?
So, I mean, there are multiple policies going back into the secondary plan that speak to compact form, that speak to a development form that will contribute to providing and bringing on forms of housing that are intended to be developed in the KDA. There are policies which speak to 3-bedroom homes in terms of need. There are policies that refer to a percentage requirement in development for affordable housing. There are policies and standards that speak to and provide for the certainty for the development industry as to what they can proceed with, all of which is a form, in my opinion, that contributes to bringing on accessible housing.
Okay. In the event my question wasn't specific enough, we see from the PPS chart that you have, it makes specific reference under that subsection F, establishing development standards.
Yes.
Okay. And those development standards have to minimize the cost of housing.
Yes.
So I'm just asking you, before we go any further, point to me in the secondary plan. Just point to me. Use, if you'd like, exhibit 33, tabs 19 or 20, just by topic, and point to me which sections in the secondary plan or the zoning bylaw minimize the cost of housing. So I'll be honest with you, I don't see any. I don't see a standard that is proffered in this bylaw that minimizes the cost of housing.
Let her answer the question.
So again, there are numerous, we'll call them broader, higher level policies that contribute to providing what I would, as I have indicated, accessible housing in a form that is compact and efficient. And the policies themselves set out certainty for the type of development that's expected and anticipated to evolve in this area to contribute to housing supply. There are specific policies, I'm just trying to find them with respect to housing, again, in the secondary plan. And those are found in the secondary plan on page 1210 of the secondary plan in section 12.2.6. And that's the section that's dealing with character areas. And there's a series of policies related to those different character areas that provide for a mix of housing forms. And this specific policy introduces a minimum requirement for 35% of new dwelling units to be affordable. And that's in relation to both the city and the regional targets. It also references affordable housing shall comprise of a mix and range of type, lot sizes, unit sizes, functions, and tenures to provide opportunities for all household types, including larger families and seniors and residents with special needs. That policy also suggests medium density or high density shall demonstrate how the minimum 35% target is met or exceeded. It also goes on to speak to the high density development providing for the larger 3-bedroom units, and it speaks to new rental accommodation being promoted. And it would be my opinion that these policies, as one example, are providing for certainty in relation to affordable housing, which will assist in assuring there are minimized costs with respect to housing. And this is just in relation to housing policies. The policies that relate to mix of uses and built form and height provide for a flexible built form approach, which again provides certainty in terms of the types of buildings that can come forward under this plan and be implemented to provide for accessible housing. And
sorry, you finished?
I was just speaking specifically to the zoning bylaw. Again, the zoning bylaw sets out a zone which allows for a broad range of housing types and forms. and also sets out standards for development, which relate to, in my opinion, more compact forms of development at certain densities that can provide for accessible housing.
Does the parking component that's being proffered here minimize the cost of housing?
I'm not sure I can give a specific opinion as it relates to that, other than a general comment that the reduced parking ratios, again, provide for a more compact form of development with reduced parking that can contribute to lesser costs in relation to the provision of parking spaces or underground parking.
I take it you are aware, if you're not, you'll let us know, that North Elgin is of the view that the parking strategy proposed by Lee Consulting.
Mr. Chair, I'm just raising an objection because the parking issue has already been ruled as it relates to NEC's position to be a site-specific phase 2 matter. So I don't think this is it's starting to get into an area that's phase 2 evidence.
I would absolutely disagree, and I think we have to go back and pull up all the tapes to convince you sitting here today that that is incorrect. I was prepared for this. We should go back to the issues list. Parking is on the issues list. It's on the issues list, even though they cut it off the issues list, they still left it on the issues list.
You have yet to reply to their redrafted issues list for both phases as of yet to have this sort of discussion. They have proposed now that it is phase 2. Phase 2.
It's not
phase 2
on the issues list as phase 2. Okay, hold on. Can we pull up exhibit 13, please? Otherwise, I'll have to get my own copy. So do you happen to have happen to have a copy of exhibit 13, the issues list in front of you?
I do 13? Not. Bear with me.
What's he talking about? Checking right now. It's just this part that should an oversight.
While they're looking around, just a question to Mr. Cherniak. Is your client taking any issue with the parking standard KDA wide in the zoning bylaw that's before the tribunal? Does it want a different parking standard?
Can you please go to exhibit 13? Oh, sorry.
All right, Jason, it looks like the members are still looking for something. If you're able to answer, it would help me.
We are also live. Could we have this conversation offline at this point?
Oh, absolutely.
Okay, thank you.
I do not have one. These are all just the bottom. No.
Somebody share onto me.
I can share my version on screen. I just have some my own highlights on it, but I'm confident that paragraph 85 of that revised exhibit leaves parking as a live issue.
We will have to apologize to everyone because the nature of this hearing the nature of this hearing makes it very difficult to have organized the exhibits in advance because we've been dragging them back and forth. So we will have them organized by the time we resume after lunch. Our apologies.
Sorry, I'm putting it forward that Exhibit 13, paragraph 85, it specifically leaves parking as a live issue on the table for this hearing. There's no redaction or anything cut off from that. I'm happy to post my version on the screen, but and I think I will, just to make sure that I'm not sure how much of it will come up on screen, but we will see. Apart from the red, paragraph 85, even on their own wording, says parking is a live issue. There are other places where it says parking is a live issue. So
apologies. So Mr. Chair, obviously the city is putting forward a parking standard in its zoning bylaw that applies KDA wide. So the city had to, of course, and did call general evidence supporting that parking standard. NEC can raise an issue generally asking what was the basis for that standard. Where it becomes a phase 2 issue is where NEC starts to call evidence or get into questions about a site-specific standard. Because I put to you, Mr. Chair, if you look at the evidence that, at least the witness statements and the reports that NEC has filed, they're all about seeking a site-specific standard for its property. So to the extent that Mr. Streisfeld goes into those areas, that's phase 2. If he has a general question, as in what is the basis for the minimum and maximum rates in the KDA wide bylaw, that's fair game. That's evidence that we've already led. So there's sort of a line between what is phase 1 and phase 2 as it relates to parking. And Mr. Chair, the only other point I'd add is the June 29th disposition from the tribunal indicates at page 12, paragraph 19, that whether the minimum parking requirement can be reduced, raised by NEC in the northeast quadrant only, is a phase 2 issue. So it's already been decided on even before we came into this hearing. And then the tribunal, of course, ordered the same at the commencement of the hearing.
So let me take a step back for one. May I?
General rather than site-specific? Yes. Questions?
North Elgin has never accepted this notion proffered by council for the city that its parking strategy was intended to be site-specific. This has been a fallacy. I'm going to talk probably fake news that has been continuing to be asserted before this tribunal, and it's continued to be so. So what I'm saying,
Self-associated with.
yes, fair enough. It is incorrect on the principle that was just proffered. And so we're going to go continue to go back into this.
Mr. Streisfeld, I'm very sorry to cut you off. I'm concerned that this witness is probably not even going to be able to address. Are you just asking her for the policies that she's aware of and has perhaps put forward? I can't follow you in your questions of this witness right now.
Well, because we're being stopped before we even start.
Let's
Well,
restart and let the panel see where you're going.
well, I understand that, but right now, I thought we were dealing with this issue that somehow we are not allowed to ask any questions relating to the Lee report, which we incidentally, I referred you to earlier. It has nothing to do with what a tribunal previously may have said. I'm prepared to address that as well, because the fact of the matter is that Mr. McCooch, both in issuing the procedural order and then in issuing his decision after he issued the procedural order, made very clear in paragraph 26 of his decision that he knows he had already issued the procedural order with all of the issues that were going to be the subject matter of the hearing. So when my colleague says that Mr. McCooch, who was sitting in a pre-hearing conference matter, said something, well, I beg to differ with you, because by virtue of paragraph 26 of his decision, I'm going to pull it up so that we're clear about that. I believe that was exhibit 40, if I'm not mistaken. Can somebody help me? Was exhibit 40?
Yes.
Thank you. Let's take a look at exhibit 40 for a second. So this is exhibit 40, and I want to go to paragraph 26. The tribunal issued the procedural order which will govern these proceedings, including a specific issues list on June 24th. Now, if we go back to the June 24th, which is exhibit 15. You have all of the issues that Mr. McCooch said were live issues for the phase 1 hearing. Now, I don't think you can read this any other way. And we would like that specifically recognized at this particular point that the tribunal has said twice that it had issued a procedural order, including specific issues list. Paragraph 26. So now I want to go back to exhibit 15. Let's see if we can pull that up.
Mr. Chair, while my friend is searching for the document, I just want to point out, I think this is now the 5th or 6th time that my friend respectfully is purporting to relitigate an issue that has already been heard, adjudicated, and determined by this tribunal. You have already heard about the chronology that at the time the procedural order was issued on June 24th, Mr. McCooch had not yet issued his disposition with respect to what's appropriately a phase 1 issue and what's appropriately a phase 2 issue. As a result, in order to get a procedural order and issues list issued so the parties could move forward with their witness statements and hearing preparation, we included the note at the top of the issues list, which makes it clear that by consenting to the issues list, no one is waiving the right to object that an issue is not appropriately before the tribunal, including on the basis that it's a phase 2 issue and not a phase 1 issue. When Mr. McCooch subsequently issued his June 29th order, which chronologically post-dated the procedural order and issues list, he made the specific finding that my friend Mr. Carr just took you to a moment ago. Paragraph 19, starting at page 11 over onto page 12, and at the top of page 12, he makes it clear whether the minimum parking requirement can be reduced, raised by NEC in the Northeast Quadrant only. He made a finding guiding the procedure for this hearing that that's a phase 2 issue and is deferred to phase 2. You have already heard evidence and submissions on this point at least 5 times. My friend is now trying to relitigate it a 6th time respectfully. He should not be permitted to do that.
So again, I don't think that that Mr. McCooch could have been any clearer
on it being yours being a site specific as
well. It's
we
not.
were only dealing with the general that has been proposed.
And I still don't understand the question that you're directing to this witness. Could you just clarify that question? Because I'm lost.
So on the assumption that the city has mischaracterized North Elgin's parking strategy,
And that they have mischaracterized.
100% they've mischaracterized it.
Okay, that's your view.
Well, it's the view of
Okay.
the view
Sir,
of
Go
the
ahead.
Please
witnesses.
direct
Go.
the question to this witness, please.
Are you aware that as part of North Elgin's case, that their position is the city doesn't have a parking strategy? Are you aware of that?
That is as expressed by NEC.
Yes.
Their issues identify that.
Right.
Yes.
So you understand we're coming at this from the perspective that what is being proffered to this tribunal, whether it's through the secondary plan, but more importantly, the zoning bylaw, the city doesn't have a parking strategy. And they certainly don't have a parking strategy to minimize the cost of housing, which is something I believe we are bound to try to do as part of this approval process. Would that be fair?
And I would disagree. I would provide my opinion that the city has undertaken work to identify appropriate policies for parking and implementing parking ratios. And I indicated through my evidence witness statement that I rely on the parking analysis and the opinions of Mr. Dahl and Mr. Chai, as was provided in their witness statements and presented to the tribunal in relation to appropriate parking ratios to implement the secondary plan.
I understand that. I just want to get your confirmation that you understand North Elgin's position is, well, the evidence that was the subject matter of our witness statement is we don't believe that the city has a parking strategy. I'm just saying, you understand that that's what we're saying?
Again, I think NEC's position appears to be they do not agree with the city's position, whether that's referenced as a strategy or appropriate policies and ratios.
Okay.
There's a
Please.
difference of opinion.
Okay.
Let's just leave it there and move on.
And in any event, do you also understand that, at least from North Elgin's perspective, it is proposing a KDA-wide parking strategy? Do you understand that to be the case?
That's where I'm going to object, Mr. Chair. It's contrary to Mr. McCooch's findings, and frankly, it's also contrary to his own witness's evidence when we get to that point of the hearing.
You want to show me where that is going to be contrary? Because if we're throwing stuff like this out, we need to know where it is.
So
We don't know where you are.
Mr. Chairman, it's Mr. Kagan here, and I've resisted saying anything for a while because Mr. Kussner and Mr. Kahar are doing such a good job. But I believe Mr. Harrington will agree with what I'm saying. I need the tribunal to understand that this debate affects much more than just the city and Mr. Streisfield's client. My client is content with and does not oppose the city's parking standard or parking policies, the parking policies in the OP and the parking standard in the zoning bylaw as it applies to its lands. And we've known for a while that NEC has been trying unsuccessfully to apply a different parking standard KDA wide, which we have resisted. And we are we agree with Mr. Kahar and Mr. Kussner that this issue was already debated and already decided by a previous panel. When my client's witness got up to testify, he didn't even have to give evidence on the parking standard because he supported the city's evidence, and there was no attack on the parking standard as it applies to his lands. It's a complete waste of time and completely unfair that all of us have to keep defending the same position and the same ruling over and over. And if Mr. Streisfield wants to continue to do that, it has to come at the expense of the time he's allotted to cross-examine Ms. Anderson. He can't do it and add to that time. And that's what I wanted to say, sir.
And if I could add my comments to Mr. Kagan's, it is a real shame that all of our clients have to continuously pay money hand over fist to attend this hearing and defend against Mr. Streisfield's client's idea for our parking standards for the NEC lands. They characterize it as a KDA-wide parking standard. It's really the parking standards that they desire for their lands. And we in this process have collectively said, if you want your own parking standard for your lands, you can fight for it in phase 2. But those of us who accept that the city has appropriately determined parking for our lands and are prepared to accept the standards that the city is proposing on our lands, we have this phase 1 hearing to show that those are justified, which the city has done through its own evidence. So again, if Mr. Streisfield's clients want their own parking standard, phase 2 is where they can get it. It is not fair for them to drag us into their site-specific fight over parking standards. It's got to stop.
It's never been a site-specific fight.
Yes. You want to say something? Yes, Mr. Streisfeld.
It's never been a site-specific fight. And this is exactly why I had organized my cross-examination to first of all find out what is the policy documents that we're going to be dealing with today. Secondly, then going through my own exhibit book just to note what documents form part of the submissions which the tribunal has to have regard to. And we've pointed that out, that's under 2.1. You can't ignore our submissions that are in the material because you're bound to look at them. And then as we move forward from that, I'm trying to clarify through this witness an issue that I would have thought is basically fundamental. This tribunal maybe seems to be under the assumption that what they've tendered in terms of the parking is just good enough, and that's it. We don't need to do anything else. But we have a witness here who's proffering an entire bylaw, amongst other things. So I just don't understand how I can't get into whether or not what's being proffered is appropriate when we have a better idea. I thought that the chair had indicated suggest anything to her during cross. Well, this is exactly where I want to go. I can't even get going because we're trying to figure out what documents we're using.
Go any further unless it's a very general questions on what the city has proposed, not your proposals. You got her, she disagrees with you, and we're going to leave it at that. Move on to another area.
Mr. Chair, if I just may assist and respond in part to what Mr. Streisfeld raised as it relates to the Lee report. So right in Exhibit 33, which is NEC's document book, you go to tab 5, there are submissions, and as you work through there, you find the Bernard KDA Parking Standards Review Report from Lee. That document is the primary source in my submission of Lee's analysis on parking. If I go to the introductory section of that report, and I'm just going to read out the first few sentences. Lee Consulting Limited was retained by North Elgin Center to review the secondary plan and zoning bylaw for the Yonge and Bernard development area, Bernard KDA, in the city of Richmond Hill, and to prepare a report supporting and outlining a sustainable parking strategy, including parking rates, and this is the important point, for NEC's concept plan on file with the city. Its analysis was specific to NEC's concept plan. That's why we're objecting to the Lee report, an analysis that relates specifically to reduce parking standards, because they're all designed for the purposes of Lee's lands. Sorry, not Lee's lands, NEC's lands. Apologies.
Can we move on?
Please.
I'm sorry, I'm not clear about where we're at with my ability to raise Lee's questions and concerns with this witness on parking.
I think you've got it. You're not.
I'm not.
Yeah.
Okay, thank you. So I just want to make sure. So it's September the 8th at 11:35, and I was denied that opportunity. Thank you.
Set, I think, for a break because, you know, we've been going over an hour and you've already used up 80
That's the way
of
it
the
goes.
minutes. No, it's going to have to move on a little faster, a little more cogent and a little more directed, I think. We're going to take a 10-minute break right now.